Welcome, everyone, and thank you for joining us today. As you know, we're going to be talking about marriage, divorce, separation, your will, and the new legislation. In 2021, the Ontario government passed some amendments to estate laws that have affected things like virtual signing of wills, gifts to minors, and how marriage and separation will affect your will. Now, some of these changes have already taken effect, but what affects marriage and separation will come into effect in 2022. And we wanted you to have a head start and know what's in store. So I have invited three very capable lawyers from Hummingbird Lawyers. And today we have with us Amy McAlpine, who's a partner of Hummingbird Lawyers, and she heads the wills and estates practice, bringing more than 21 years of experience to Hummingbird Lawyers. She's a Boston native, and she has experience in preparing estate plans, but for both simple and very complex situations for high net worth families, family-owned businesses, and special needs family members. She also, in addition to her estates and wills practice, she does estate litigation. And her litigation practice focuses on will challenges, passing of accounts, and fighting for common law spouse entitlements. So if you're thinking about fighting an estate, Amy is your person too. And she provides legal support to family law and civil litigation matters with respect to constructive trust claims and dependent support claims. The other beautiful lady and very capable lawyer from Hummingbird Law who has joined us today is Ella Eyase. Ella is a senior associate in the family law team at Hummingbird Lawyers, and she works on a variety of family law cases with a special focus on cases involving property and financial issues. As you know, when it comes to divorce, usually the fight is over financial matters. Her legal work experience includes family law matters with some prior work on civil litigation, corporate, commercial, and immigration files. This combination of background has led Ella to acquire the essential skills required for dealing with all aspects of dynamic and complicated family law disputes. Ella also has a passion for community service and volunteer work and is involved in different volunteer programs. I've known Ella actually for quite a few years, and she's been a wonderful volunteer on my Joy of Aging fundraising committee for Mackenzie Health Foundation, and she's currently a volunteer on the One Life Gala committee that I'm chairing for Princess Margaret. It's an inaugural fundraiser for Princess Margaret Cancer Foundation, and mark April 23rd, 2022 on your calendars. We hope you can all join us. You'll be hearing more about the gala in the coming months. And last but not least, we have Yulia Vinogradova. Yulia is an associate with the Hummingbird Estates legal team. As a litigator and a wills, trusts, and powers of attorney drafting solicitor, she offers a unique set of skills to thoroughly understand her clients' needs and to provide tailored advice. She uses both litigation and the alternative dispute resolution strategies to best represent her clients. So Amy, Ella, and Yulia will lead a panel and share a presentation with you that actually has many interesting real case studies. And through those, they will illustrate how the new laws are different from what we had in the past. Please feel free to put your questions in the Q&A section at the bottom of your screen. We will have a question and answer period At the end of this session, some of you have been kind enough to send us some questions ahead of time. And because of that, you will get priority. We will start with those questions. So please join me in welcoming Amy, Ella, and Yulia from Hummingbird Lawyers. Over to you.
Thank you so much, Tina. Thank you, and hello, everyone. Good evening. I am Amy McAlpine, and as Tina had mentioned, I am a partner at Hummingbird Lawyers, and I do head the estates department. And as she said, it covers everything before and during and after death in terms of issues. There's a very interesting crossover between estate law and family law. And I brought with me two outstanding lawyers that will be discussing real cases. We're going to talk about what the changes are in the law. And with these real cases, they're going to be able to discuss how these two worlds collide and how the outcomes of those cases would be different now than when we had them originally. So I'll have them each just introduce themselves very quickly. I know Tina did a beautiful job, but just so you know who is who with the face. Ella?
All right, thank you, Amy, and thank you, Tina, for that amazing introduction. And also thank you, Tina, for always leading by example in your community work. And it's a great, privilege to be part of your team in that regard. As both Amy and Tina said, I'm a family law lawyer. So that means about 85 to 90% of my cases deal with separation and divorces. Usually 10% are marriage contracts, which are prenups. And unfortunately, when it comes to the happy part of family law, which is adoption, they represent less than 1% of my files. So as a family law lawyer, when somebody comes to me, I have a checklist of questions that I ask them. And the first question I ask is actually, do you have an existing will? Whether they answer yes or no, it does matter in how we design the strategy of the case. And it also matters a lot in the context of the new legislative changes, which we are going to talk about more in detail today.
Hello, my name is Yulia Vinogradova, and again, I want to thank Amy and Tina for the beautiful introduction. My practice, as Tina has mentioned, it involves separate aspects, which about 1/3 of it is preparing wills and powers of attorney. 1/3 really actually split between assisting with administrations of estates, and that could either be certificate of appointments or the general day-to-day guidance to the estate trustees, or also when people are acting as powers of attorney for property, we also provide assistance and guidance on the management of property for somebody who's incapable. And of course, there's always litigation when there's dispute, whether it's a challenge for a will that was poorly drafted, not by us, or whether it's a wrong transfer or questionable transfer to one of the children when there's 4. So there's various circumstances, and it is always best to consult with a lawyer when there is a situation just to get an opinion. And I wanted to advise that as part of this presentations, those that have attended today will be available. We will be available for 15-minute free call discussion on either matters that we discussed today, or if you have a specific question. So we do want to extend that courtesy. And similarly to what Ella suggested, that when clients come into her, I also ask a question, what is the common law status? What is the marriage status? Is a client that's planning to do their will going through a divorce or going through a separation with the new changes? So there's a big crossover between family and estates law that we're seeing, and we're happy to provide the highlight of the legislative changes that Amy will point out to you now that will be implemented as of January 1st, 2022.
All right, let's dive into it. So in April of this year, a legislative bill 245 was passed with full royal assent. And the two major topics of what we want to focus on tonight, the two major changes, one is right now, marriage, well, with the new law, marriage does not revoke your will. So you may unintentionally not provide for your spouse if you have an old will before you were married. So this automatically can cause a lot of estate and family law problems, as we'll soon see in the examples that Ella and Yulia are going to discuss. Before this legislative change, the act of becoming legally married automatically revoked your will, because there are entrenched rights of a legally married spouse. Now, divorce did not automatically revoke your will, which is quite shocking, because you would think it would be the opposite. If you got divorced, it would automatically be revoked. So now it's the other way around, and it does not. So really important, just big overview is that getting married, your old will is still in place. The second major change right now with the new law is whether you are separated or divorced, any gift in a will or any entitlements, statutory entitlements that you may have as a spouse will now be invalid. Previously, it was just applied to divorced people. And by now, including separation, I personally think that this is a major improvement in the legislation, because now we have, and we've seen situations where people are separated 20 years and technically they're still legally married. So that would give them the right to try to collect under the will as a spouse and or try and make a legal claim against the estate if there was no will. So really important there is that the separation and divorce is going to invalidate any clause that has to do with them within the will or any entitlement under the law. Ella and Yulia are now going to talk through an actual file that they handled at our firm to show you how each of the changes play out before and how it would play out now with this change. So we're really hoping that this will allow us to have a better appreciation of the effects of the change. We're going to deal first, Ella's going to tell us about the first case, focusing on the first change that I mentioned, with that the act of marriage does not revoke your will. So Ella, if you want to go ahead and start with this first case.
So for confidentiality reasons, we did change the name of our clients, but this is their true story. So the first story we're talking about is John and Emma. And John first came to our firm in April 2020, and his main objective was to make sure that his new wife, Emma, would be taken care of after his death. And this was their story. John and Emma started their relationship in 2014. At that time, John was actually going through separation with his former spouse, which we will call Brandy in this case. And after their separation, John and Emma started living together. In early 2018, John was diagnosed with kidney cancer. He went through first round of treatment and he responded well to treatment. John and Emma were extremely happy about his recovery, and John proposes to Emma in December 2018. This was to celebrate this new occasion, this new chance at life, and to build a life together. Unfortunately, a little bit after their engagement in December 2018, John's cancer came back, and this time it was very aggressive. And John and Emma immediately started trying all kinds of treatment plans, traveling around the world to find a cure, and they were extremely hopeful that John will get better and he can walk Brandy down the aisle. And that was their goal, and that's a sentence they said to me many times. However, John got worse and their hopes got dimmed. John had a different lawyer before he came to us in April. And at that time, he was telling his lawyer to draft a will for him, naming Emma as the beneficiary of his estate. This will was drafted, but he couldn't get it signed. And mind you, in April 2020, this is at the start of the COVID-19 pandemic. The hospitals are crazy. Nobody's allowed in. So it was very difficult for John, who was in the hospital, to have his lawyer come and provide him with a will to sign. And he was also going through a lot of pain. So it was difficult for him to focus as well at the time. So John and Emma decided to get married in the hospital in February 2020. And a few months later, John did pass away. He actually passed away in May 2020. So as I mentioned earlier, John did have a former spouse named Brandy. After their separation back in 2014, Brandy was receiving monthly spousal support from John. And as a part of their final agreement, and this happens a lot, sometimes the person who owes spousal support or child support would name the other person as a partial beneficiary of their estate or their life insurance plan, so that in the event they die while they owe a spousal support obligation, that person would be taken care of. So there was an existing will that John had, and this was the only will that John had. Now, Yulia will tell you what happened in this case and what could have happened if the new legislative changes were in place at the time.
Thank you, Ella. So under the old law, John's 2018 will was revoked when he married Emma in 2020. That means for the purposes of the estate administration and the division of John's estate, it was as if technically John didn't have a will. And so when someone dies without a will, it is called intestacy. And in Ontario, there are laws for what happens if a person dies without a will. The act is called Succession Law Reform Act, but I won't bore you with the specific provisions. Basically, it provides that Emma, as a legally married spouse, has property rights. But those property rights are not automatic, that somebody says, okay, here you go, you get everything. She still has to make a claim. So in our case, Emma started a legal process. People rarely do this themselves. It could get quite complicated, and she continued with our firm. Under the old law, Emma, as a legally married spouse, has a right to make a claim under the estates law or under the family law. So a legally married spouse, like Emma, has a choice to make. Under the estates law, because John had no children, Emma, pardon me, Emma could claim the entire value of John's estate. Where situations are such that there are children, the law prescribes for the portion that goes to a legally married spouse, and the division depending on how many children there are in the family or the deceased had. Under the family law, Emma could ask for half of John's estate. That process is called equalization, but either way, Emma had to make a claim. But Emma was not the only person making a claim against the estate. You remember Brandy, the common law spouse. Of course, under the will, she was entitled to receive a portion of John's estate. And she took it to herself to sue in court. And she actually alleged and claimed that Emma's marriage to John was what's called a predatory marriage. Think of, Emma as a big tiger preying on old poor John, although John wasn't really poor. And so the allegation was that she didn't really love him. She was after his money. So Emma had to defend herself in several actions because, remember, under the old law, the marriage revoked the will. And so you now have two competing claims going after the estate. So Emma hired us to represent her, and after countless hours of defending and trying to get at the true intention of John's relationship with Emma, John's intentions with Emma, John's intention to share his estate with Emma, over $100,000 in litigation costs and legal fees, ultimately the parties settled at a mediation. But you can imagine all the stress it has caused to both women fighting, where really Emma wanted to grieve her husband instead of defending her rights. So what could happen under the new law, and Ella, if you can switch to the next slide for us, please. Thank you so much. Under the new law, what would be different is that a marriage would no longer revoke a will. That means that John's will that he had naming Brandy as the beneficiary would still be in place. And so you would think it would leave at least one woman happy, but the litigation wouldn't have stopped because the new law still protects legal spouses' rights. So Emma, as a legally married spouse, would still have the right under the new law to make the same choice whether she wants to claim for all of John's estate under the estates law or equalize, which means I try to ask for half of John's estate. So you see, we would still be in litigation battle because John did not update his will, right? And so the focus of today is that we want to drive release. There's changes, but either way, estate planning with qualified professionals that can give you qualified advice is the most important thing, I think, that to avoid or to reduce the risk of litigation and to account for the various factual patterns that each family may have. So right now, I'd like Amy to please highlight the takeaways from this case that we want to have when you are planning your estate for what you should be keeping in mind moving forward.
Sure, thanks. So I think that you did a beautiful job on laying it out, and again, just repeating the message of if you get married, your will is not revoked. So any major milestone, I tell clients in your life, if it's births, marriages, divorce, separation, deaths, anything that you're celebrating, good or bad, you should be thinking about how does this affect my will and how does this affect my estate planning? And you should be in constant contact with people like Tina, your advisor, and your lawyer, so that everybody is communicating and working together, making sure that your will covers all of this. So specifically, if you are thinking about marriage and thinking about saying I do, I want you to think I will, because your will is going to be so dramatically important. And to prevent the struggle and the family mishaps of common law spouses, previous spouses, or a new spouse, or even family who are going to be very sensitive, especially to a new spouse, the most cost-effective measure that you can take is 100% proper estate planning, as Yulia said, with a lawyer. It's not the item to cheap out on or to try to do it yourself. Wills are not fill in the blanks. So I highly recommend that these are the issues that you don't know what you don't know, right? So these are the issues that we are trained to identify on the family law end and on the estates end, in order to prevent all the discord and litigation after. And trust me, it's a lot more expensive after the fact. The only difference is you won't have to listen to it. But so now we're going to focus on the second major change, which is that now if you're divorced or separated, that now separation is included with invalidating gifts and entitlements. And I believe, Yulia, you're going to give us the facts of the second case that you actually had.
Thank you, Amy. That's right. Both me and Ella actually acted on this file. So it was quite interesting because, of course, the names have been changed to preserve confidentiality, but we'll call it the story of Kylie and Miguel. And Kylie and Miguel were married for 30 years to each other. both had wills prepared years before any trouble had started between them. The wills were not prepared by us, and the wills had named each other as beneficiaries. Kylie and Miguel had no other children, and actually there was no other family members that were involved with the estates afterwards either. So after 30 years of marriage, Kylie and Miguel go through a very messy divorce. And any divorce starts with a very messy separation. So during the period of separation and fighting tooth and nail for the fact that they didn't want the other to get anything. Now, these were not very wealthy individuals. They had pension, they were hardworking, they had a matrimonial house, which in the course of agreeing on the terms of separation was sold for about $1 million. For, you know, we rounded up the figures so we keep it simple. And after the 2 years of messy separation, after the sale of the house, Miguel and Kylie agreed to sign the separation agreement. Ella had acted for one of the parties, and she prepared a very detailed separation agreement. After they signed it, Miguel and Kylie would each have $500,000 from the sale of the house, as well as Miguel had half of Kylie's pension. Now, interestingly, in this case, that nobody had foreseen when we were signing the separation agreement involved, is that 1 month after the separation agreement was signed, Miguel died. Now, nobody had time, or the divorce order has not been applied for yet. So you see the conundrum. The parties were still legally married. Under the old law, it didn't matter they were separated or not. And the only other document that affected how their separation or how their estates will act was the separation agreement. And that is because under the separation agreement, one of the terms specifically said that the parties, so Miguel and Kylie, gave up any claim, any entitlement to each other's estates. So that added to the more of the confusion, because you now have a legally binding contract, separation agreement, and you also still have a valid will. Now, the will named Kylie, because it was prepared years ago, as the sole executor, the sole beneficiary of everything. And so through all this confusion, obviously lawyers were involved. Now, the added layer of complication was that now Miguel was dead, and without a proper estate trustee, who was the instructing mind for the estate? So obviously additional parties were involved. In those cases, it often, could be that you have the public guardian and trustee step in. So added costs is what I'm trying to communicate here to the estate to reduce Miguel's $500,000 effectively. So Kylie at some point, Miguel's family lawyer took the position that Kylie had no rights to the estate because of the separation agreement, and that because she gave up all her property rights, that she was not a beneficiary under the will. And Ella will share with you what happened next and under actual circumstances under the old law, and then what could happen under the new law.
Thank you, Julia. Yeah, so everybody wants to know, I guess, that Kylie finally get Miguel's $500,000. So as Julia very well set it out, in that case, the separation agreement was very detailed, and usually when we enter into these agreements, we want to make sure that our clients have no reason to come back to us. It has to be a document that completely addresses all the loopholes and ties up all the holes so that each party after separation can move on with their lives without the need of having to be dragged into another legal battle. So in this case, because of our release clauses in the separation agreement, Kylie did not get anything. But at that time, the only thing Miguel had was around $600,000 in his bank account, which was basically 1/2 of the value of this home that Kylie and Miguel had built together, and half of Kylie's pension. So it was a very hard thing for her to understand and accept that if Miguel had died recently after the division of those assets that she had put her entire life into, how come was it that this asset would now just sit there and we didn't know who was going to get it? So in the end, what ended up happening is it was given to charity. So that was one good thing that happened out of this case. But again, if it was under the old law, if the separation agreement didn't exist. So just imagine, because the timing in this case was very interesting. They signed it, and then it wasn't that much longer that Miguel had passed away. Had they not signed it, even if the separation agreement had been negotiated, even if it had been drafted, let's say Miguel was on his way to his lawyer's office to sign it. Kylie had already signed her end, and he was just about going there to sign it, and he had a car accident, and that's what caused his death. If those were the circumstances, Kylie would still get that $500,000. So just because that separation agreement was signed, that was the only thing that prevented Kylie from getting that money that was basically Miguel's estate. So under the new old law, if there was no separation agreement or the timing was a little bit later, then technically Kylie would be entitled to everything as the legally married spouse, especially that Miguel had no other beneficiaries, and as well as the old will would not have been revoked. But now we're dealing with the new law, which says separation revokes your existing will. So let's assume again, to recap, it does say that the new law, which comes into effect as of January 1st, 2022. So again, just be mindful of when these changes take effect. So if you're getting married by the end of this year, or you're getting separated by the end of this year, so the old law might still apply to you. But does a separation agreement matter? So obviously we showed that it did matter. It was monumental under the old law. Does it still matter under the new law? If the new law says once you're separated, any gifts you've made to your former spouse are revoked in your will, does it still matter? I would say yes, it does. And that basically is due to the definition for separation that's provided under the new law. So it basically says, unless you have an existing separation agreement, or unless you have a court order that confirms you've been separated, you must show that you were separated for 3 years prior to the deceased's death. So that becomes a fact-finding endeavor. Basically, now you have to show, was it 3 years or was it 2.5 years? And who's giving evidence? Is one spouse versus other people who have claims to the estate? So it becomes very difficult. So this is why I would say the separation agreement still matters, because you definitely don't want your former or the spouse that you're going through a nasty divorce or nasty separation with to get your estate or any monies that you have left. So it's important to make sure that you address their entitlement, or maybe you do want it. You're saying, even if we're separated and I pass away, maybe I want them to have some rights to my estate. In case of Miguel, maybe if he knew that he was going to die soon, he might have thought differently. So in this scenario, because 3 years, it's a long time after separation, and so much can happen, a death can occur, and that definition might not capture it. So it could still create a scenario as if the old law is happening. Now, I'm hoping I haven't confused you with that, but I will also put the question to Yulia. So under the new law, we know that separation agreement still matters. How about a will? Does that matter too?
Thank you, Ella. I will address your question in just 1 second, but going back to Kylie's emotions, she already gave up her 1/2 when she signed the separation agreement. So having Miguel died, although she processed the resolution, I think that uncertainty for many people would think, did I find now my just lost treasure gold? And so with certainty of a will, whether Miguel would intend for Kylie to receive things after the separation, if he updated it, for example, after the separation agreement was signed, he would certainly provide clarity. So I'm an estates lawyer. Of course, I say the will matters because I think that it is the clear set way to provide to the world what are your intentions, right? There's not many ways of a person to speak beyond the grave, so to speak, unless you are a very eloquent poet, maybe. But this is, but this is a way to tell the world how you want your wealth distributed. Who are the people that matter to you? A properly drafted will, because of course the law allows for things that are called holograph wills when they are signed, written by a person themselves. But what we are seeing is that an improperly prepared will is what Amy and I litigate. So when you have a properly drafted will that clearly defines what are your intentions, you have control. It is not left to a legislation. For example, you know, if the legislation indicates what happens on an intestacy, meaning when a person dies without a will, it also may not be exactly what you wanted. And so a will, I think, is always important. Ella mentioned with the changes to the law that there is still gray area. And I just want to add to that a little bit, that the intention, I think, of the lawmakers is to remove confusion. And by creating the separation clause and the changes, they're avoiding a hole that we were seeing before, where people didn't go through the divorce, but lived apart, lived in different countries, were separated, potentially had common law spouses, right? That they were common law spouses, even though they weren't legally divorced. And so I think the lawmakers, for lack of better term, were just creating a one scenario fits all. But we all know that's not possible. So without proper estate planning, there's no way to deal with everyday's factual differences that your life may have. So don't leave it up to the legislation. And, you know, it is not possible to make a one model fit all. So for example, as a legally married spouse who are separated for 3 years, as Ella said, 3 years is a long period of time. And in preparing for this presentation, me and Ella actually had a discussion about what happens if people reconcile, right? A properly prepared separation agreement, Ellen, correct me if I'm wrong, can address that, right?
Yes.
And you also mentioned, and I'll pose a question to Ella, you know, what is the biggest question that you deal with when you're dealing with divorce applications or separations that you think would be relevant for under the new legislation?
I mean, people always want to ask about, you know, their date of separation because it's an important date. It's a date your asset gets valued as of. And under the Family Law Act, death is a separating event, right? But this idea under the new law is, did this actual separation occur before the death? And if so, how long were the parties separated? So if you don't have a document that in a separation agreement, we always put they were married on this date, they were divorced on this date, because those dates really matter. And this is one of the gray areas, I would say.
Because especially now, one of the person who's arguing on which day you're separated is dead. So
Yes.
whereas in right, so you instead of having he said, she said, you're just going to have one person arguing in whose favor the statements would be. So again, additional confusion and cost for more litigation to try to find objective external evidence to prove when was separation. Did they really fit within the 3 years? Was there reconciliation? So I know we kind of started having a discussion between the panelists about how we feel about the new and what that would mean for us. But I wanted for Amy to please highlight, you know, some of the takeaway that people should consider when they're thinking about estate planning starting January 2022.
Sure, thank you. You know, I don't want to beat a dead horse because I think you guys very clearly laid out the importance of now being separated and divorced, what happens. In my opinion, I do think that this was a good closure of a loophole. However, what I really feel like the major takeaway is I think it allows us to a moment to take a step back and to look at estate planning as a whole. And we have to consider how important consistency is, whether it's with separation agreements or cohabitation agreements, marriage contracts, or what people call prenups, along with what their will says, and then even with their designations. So your life insurance or your pension or anything that has a beneficiary designation, are those designations consistent with your entire plan? So your estate plan is really all encompassing. And by going to an estate lawyer, they are going to know all the questions. Sometimes clients, they get an intake form and they think, oh my gosh, I don't want to answer all these questions. What does it matter? Because it makes a huge matter. And it's about us knowing the left hand needs to talk to the right hand in this situation. So it is very important that all of these pieces come together and are cohesive and make sense. This is especially important for common law spouses, because common law spouses are not treated the same as legally married spouses when it comes to property. So this is a really big confusion that I think Ontario needs to fix, because under tax code, spouses are exactly the same, whether it's common law or legally married. When it comes to support or financial dependence, it's the same. But if it comes to property rights or entitlements, it's not the same at all. So common law spouses have to be very, very careful, along with any financially dependent person. If you die and at that moment someone is financially dependent upon you, then you have a legal and moral obligation to provide for them. So this really opens up a whole nother can of worms. And so it's very important that all the pieces are reviewed so that there's clarity of intentions and everything is consistent. And its estate plan is plan. So just don't forget to plan. It's all different parts. Quickly before I want to be able to leave enough time for questions. And I know we have some questions that were sent in before, as well as in the Q&A section. So thank you for those. We'll get to those in just a minute. But I did want to just mention a couple other things that I think are confusing about the new laws. So first, you may have heard that they now approved virtual execution and witnessing. But it's very, very important to note that this doesn't mean that the law or the courts accept digital signatures. So we still need to kill a tree and print paper. We still need a pen and that what we call a wet signature. So although we are now to prevent and to assist with the social distancing, instead of all witnesses and the testator being in the room at the same time, we can now do it on a Zoom call. So everyone is virtually present at the same time. But again, doesn't mean that digital signatures are accepted, and they're not. So they need to, I think, catch up a little bit with but they're very concerned with fraud was the discussions. I had the privilege of being part of those discussions with the drafting of the new legislation, and the focus and concern was fraud, and especially with elders. So for now, they just said, we'll allow virtual witnessing and execution, but you still need your paper and your pen. The other thing that I'm not happy about is they've created this little law that they kind of slipped in that says that there may be an opportunity for the court to fix a defect in a will. So normally, if the will has to make every single perfect check mark, if you will, within the law. It has two witnesses, it has signatures, it's dated, etc. So we have all of these rules as to what proper execution is. And this law is suggesting that a court would be able to fix something that maybe happened that technically would have been, the result would have been that the will wasn't valid because it wasn't properly executed. What we don't know and what we don't like about this is we don't know to what extent the judges they're going to use this, and to what extent of what kind of defects. And is this only on new wills? Is this only related to the new, digital witnessing, the virtual witnessing, or are they talking about all wills? So I feel that they personally have just created a huge question mark that is going to be heavily litigated, because people are going to want to validate wills that otherwise would have been not properly executed and invalidated. So I think it's going to be a mess, and I think it was a big mistake. But as of right now, there is this possibility that if a will wasn't properly executed, we might be able to have a court recognize the mistake, maybe wrong date or wrong signature or something like that, and perhaps they will validate it anyways. I believe, Yulia, didn't you recently have a situation that this similar?
I did. I had a client that reached out to us who, during the pandemic, whose mother was ill, and who had a situation that decided to not contact a lawyer but prepare a will herself, and understood, to read and saw virtual signatures to mean that it does mean pen on paper, and had a piece of one version will printed for mom with a social worker who held an iPad, and then she was in a car with witnesses herself, who were signing the second half of the will. That posed a problem, number one, being that under the new legislation, it is not just that you have witnesses. The requirement is that the will has to be prepared by a lawyer, and that lawyer has to be one of the witnesses on a virtual call. And so I hoped that that would be potentially under the new, let a judge fix this would work. But there was a bigger problem that arose from this lady not contacting a lawyer while her mom was still alive. And the bigger issue was, what was mom giving away? So mom was in a common law relationship, and the only asset that mom held was a jointly owned house that she held with her common law spouse. And so this is a bit of real estate law. When people hold title to an asset in Ontario as joint tenants, it has an automatic right of survivorship. And so by default of not coming to a lawyer who would have told, that mom could have broken that joint tenancy and actually have 50%, that we could help her to retain for her estate, that hasn't happened. And so really there was no estate, even if we could have fixed the will. So it was an unfortunate situation that, again, we're not trying to drum our horn, but we know what we know because we went to school for it, we worked and lived in it for years and years, and there's just, everybody has an expertise or what they focus on. And I think important advice, whether it's legal, financial, or tax, is always important. And so I actually wanted to lead into our question, which were, thank you, sent before. And I'll read the question first. They are a little bit off topic from the conversation today, but we did want to address them. And as I said, we are offering a 15-minute discussion with attendees today. So if we didn't get to your question, or if you think of a question afterwards, feel free to reach us. And so I'll read the question first. Will the beneficiary of one's estate be required to pay capital gains tax upon taking possession of such estate? So what I think this question asks is, who pays the capital gains on the estate property? And so really the capital gains on estate property is the deceased's responsibility. So it will be something that an estate pays out of estate assets. That said, obviously there should always be discussions with an accountant. We are not tax lawyers, although we do know a lot. And as Ella mentioned, death is considered a taxable, well, Ella mentioned for the purposes of separation and marriage, but for the purposes of Tax Act, death is also a taxable event. So, you know, regardless of whether there is a capital gains exemption on a principal residence, there may be other assets that do trigger that capital gain. There is several other questions that I will read, and then I see that we also have a Q&A, 2 questions. So does the beneficiary of such estate need to declare funds owned by a testator in another country? And so I think what this question pertains to is to the estate administration tax that is due on an application for a certificate of appointment. That tax is 1.5% in Ontario. Each province has their own regulations. For the purposes of estate administration tax in Ontario, you do not have to include real estate in other countries, but bank accounts, you do. So sometimes people don't know what those bank accounts are, but once you discover, you do have obligations, filing and reporting that come even after you are appointed as a state trustee. So the next question is there a special form to be completed by beneficiary, or is this duty to be the executor to perform such tasks? So again, I'm not quite sure with what form is being referred to. Given the tax comments before, I suspect that it's with respect to remitting the estate administration tax. So everything to do with an estate, technically it's the estate trustee who has an obligation to do. Whether it's collecting assets, preserving them, paying taxes, it's never a beneficiary. Unless the beneficiary has an issue with what the executor is doing, then there's a court process. But it is the duty of the estate trustee to pay taxes and also to file taxes for the terminal return, for the deceased, and then for estate if there are due. The last question.
Sorry,
Yes,
Yulia, the one thing I just wanted to add to that is there is a possibility that if a beneficiary lived outside of Canada, how that money is sent to them, how their country views it in terms of tax law, whether they exempt it or whether it's part of income, is going to completely depend on the jurisdiction and the rules as to where they live. So in terms of the estate in that initial disposition, it doesn't affect the beneficiary, but it could affect the beneficiary out of the country.
Mm-hmm. I wanted to add here a real life example that I had last year. We had a client who passed away. He had 3 children. 2 of them lived in Canada, 1 lived in Netherlands, and they were all beneficiaries of his RIF. So the son who lived in Netherlands just gave us instructions. There's a form that each beneficiary has to complete to say how they want to receive their share of the RIF. And he wanted the money to be wire transferred to his bank in Netherlands. No problem. We sent it, and financial institutions do not withhold any tax, even though the RIF would be completely taxable to the estate of the person who passed away. It would be added to the income of the person who died. So the beneficiaries didn't pay any tax on it, but how that money is treated from a tax perspective in Netherlands, that's the business of Netherlands. Like, we have no idea how that's going to be treated. And all we do is, from a Canadian perspective, if you're a beneficiary of a RIF or an estate, you know, you get your share, you don't pay any tax on it. The state is responsible for all the taxes.
Thank you for that. There is one last question that I had emailed to us before. It is quite lengthy, but it deals with a private giving foundation. And so the question was, whether that foundation, without reading the whole question, I wanted to so I think because it has specific reference to the different charities, I didn't want to, read the full question.
Let me recap it. So please. The question had to do with someone who has a donor advised fund or a private giving foundation, and they wanted to know what happens in the event of that to that donor advised fund. Now, the donor advised fund is not part of your estate, because that's money that you've already given for charitable purposes. You've received your charitable donation receipt on it, and then on an ongoing basis, every year, you just grant instructions to the foundation that runs that donor advised fund for you. And when you set it up, you give them instructions on what to do upon your death. Some families want their children to be involved and carry on the philanthropy. And some people say, you know what, when I pass away, just give it to charity X, Y, and Z and close it off. So those instructions would be with the donor advised fund. They should be when you set up the fund. If you're not sure what you did, or if you don't remember, go back and ask the foundation. You can always review that documentation. If you want to change it, you should do it while you're alive and of sound mind, but it has nothing to do with your will or your estate.
Very good point.
Thank you, Tina. I do see that we have 3 questions. I can read one of them and pose it. I think it is actually posed, I think it's to both me and Ella, and perhaps if Tina, I can read it over.
Sure, absolutely, go ahead.
Thank you. So this is for, what would be your recommendation to protect inherited assets from an only child spouse after marriage? So we do see this. I'll address it first, or perhaps Ella wants to address it from the perspective of marriage. But in the will, where a person prepares a will, we indicate and we include a clause that specifically says that it is the intention of the testator, so being the person who's giving the instructions for the will, that the inheritance would be excluded property. And we do that based on the Family Law Act, which I'll let Ella speak about.
Thank you, Yulia. Yes, so under the Family Law Act, basically by default, spouses are entitled to 1/2 of each other's assets or wealth upon separation. There is an exception that says if you inherit any monies during marriage, so not before marriage. So if you inherited something and you have that in a bank account and you enter with it into marriage, you're not going to be able to exclude it. But under the law, if you inherit something during the marriage, you can exclude it unless you put it into the matrimonial home or you put it into a joint account. So if you want to protect any inherited funds that an only child will receive during his or her marriage, just make sure, as Yulia was saying, those inherited funds are specifically, it's specifically stated that that fund and any income derived from it is to be excluded under the Family Law Act. And if you have that little blurb in your will, then it shows the intention of the donor. And if it's made during the marriage, then you don't need anything else.
And I think you should talk to your child to make sure that they don't put the money into marriage, into matrimonial house or a joint account.
Yeah.
Like put it into a bank account, put it into another property, investment property, right? But just not in joint names or matrimonial.
It's usually an awkward conversation that I have with my clients when they inherit money and both spouses are there, and I have to tell them that this is what's going to happen. If you pay down your mortgage with this money, then it's going to be family property.
Exactly.
Yeah.
So we're getting close to the end of our presentation. Let's answer the other 2 questions.
Quickly, sure.
Yes, we have a couple of minutes. We can stay behind. So the second question is, if a wife signed or signs a separation agreement in 2021, Ella, this may be for you, but not the divorce, so hasn't been processed yet, what would happen if a husband dies between the time the separation agreement is signed and the divorce is finalized? Which law would apply?
Depends on when the person died.
Yeah,
Well,
if it's before
ahead.
January 1st.
If the separation agreement is already signed, and it has a clause that we spoke about where the spouses give up their claim to the estate, what we anticipate and are seeing, there is very few litigation on this, is that it will be treated as if that spouse gave away any claim to the estate because the separation agreement is finally signed. If it's just in contemplation and hasn't been signed, and the death occurs before January 2022, it is possible that under the judge can fix it law, that maybe there's a window of opportunity, but we don't know. So again, I'm not trying to be facetious, but I think that it will depend on the facts of the case, whether the separation is signed, and how much room there is to try to push it under the judge can fix it.
Mm-hmm. And always look at what's written in the agreement. That's very important. Mm-hmm. Every clause has a purpose in there, so it's hard to kind of say what would happen. It would really depend on how it's drafted.
Thank you, Ella. There is a last question that I'm going to read over. What are the consequences if both parties do not provide financial information, got separation agreement? Ella, that's your world.
So under Section 54 of the Family Law Act, that's one ground or possibility for setting that agreement aside, because the idea is you want full transparency. You want to understand what people have and what they're agreeing to. So if you're agreeing not to go after each other, you need to know what it is that you're not going after. You can't blindly agree that I don't want any share of your assets. So financial disclosure is extremely important. I will not do a separation agreement or a marriage contract if it doesn't come with financial disclosure. It's just too much liability, too much of a negligence to advise people blindly. So it's extremely important.
Mm-hmm. So thank you so much, Amy, Ella, Julia. You did a great job laying out the new landscape and the laws that are coming into force January 1st, 2022. Thank you to all of our attendees. If you have not updated your will, or if you don't have a will, make sure that you think about it. Make sure you talk to the right professionals. I always say this in every presentation that I do, that you should deal with the right professionals. And we know this when it comes to our health, we always go and see a specialist, but somehow we totally forget about it when it comes to our wills, when it comes to our financial planning or other areas of life. Estate planning is a very specialized area, and it's worth every penny that you pay a good estate planning lawyer to have a good and solid will done. So thanks again. These ladies had offered a 15-minute conversation. If you want to have any questions that you want to ask in confidence, and make sure that you take advantage of it if you are interested. We will be sending an email to all of you, and we will offer their email addresses so you can be in touch. Thank you again for joining us.
Tina, thank you so much for this opportunity, for letting us speak for you. This is an exciting change, and we're really glad to be here with you today.
Thank you.
Thank you so much. Take care. Bye-bye.
Bye-bye.